Welcome to Healthcare Business Unpacked, the podcast where we break down how healthcare businesses actually and legally work for healthcare folks operating in the Texas market. I'm Cesar Lopez, a healthcare attorney.
And I'm Cindy Peters, also a healthcare and business attorney.
And between the two of us, we have spent many years working with healthcare providers and businesses. Healthcare is one of the most heavily regulated industries, and this podcast is for us to give our perspectives as healthcare attorneys on how those businesses operate within this regulatory environment. Before we begin, a quick disclaimer. This podcast and its contents are provided for educational purposes only and do not constitute legal advice. The opinions expressed are our own and do not necessarily reflect the views of any organizations or entities with which we are affiliated. Listening to this podcast does not create an attorney-client relationship.
All right, Cesar. So what are we unpacking today?
So for our first episode, I thought we'd start with something that you and I have dealt with numerous times in our healthcare careers, the corporate practice of medicine doctrine and how it applies in Texas, or as we call it, CPOM for short. And so this comes up a lot when we are dealing with folks that want to start a med spa, a wellness clinic, or really even their own healthcare practice many times. So the question comes up when you start those businesses and you're dealing with CPOM, especially in a state like Texas, who owns the practice and why does it matter? So that's the question that I think we should kick off with. And basically in just one sentence, what is CPOM, Corporate Practice of Medicine Doctrine, and why should anyone starting a healthcare business in Texas care about this?
That's right. And Cesar, as we develop and we talk and we go through the conversation and unpack all these other issues, you'll be surprised of how many people, how many providers, licensed and non-licensed people do not know about the regulations that come around when you're trying to open a healthcare business. And you think, right, that it's like any other regular business, right? You think, but because it's a business, right, you can do it just like any other business, like opening a shop or a restaurant. However, it is not. So today we'll unpack what this often overlooked doctrine means to you if you're forming and expanding a healthcare business.
So that's a good point. I think one of the things you and I have spent a lot of time talking about, and a lot of clients come to us initially with these issues, is that maybe they've already opened or think they've opened a business. They come to us and say, hey, I started a med spa or an IV hydration service or whatever it is. And then we get into their corporate documents and we realize, they had a CPA or a lawyer, not a healthcare lawyer, but a lawyer, form these entities, draft up their documents, kind of get them going as if they would, kind of like you mentioned, as if they would a normal LLC or corp or whatever, I mean, even like a law practice, you can form a PLLC, but it's not going to be the same as forming something in the healthcare space. And so, yeah, I think, I know I've seen that a lot. I'm assuming you've seen that a lot. And really, telling folks and educating folks that, look, it's like 90% the same as forming a normal LLC or PLLC or whatever entity you want to form, but that like last 5 to 10% that's very healthcare specific, very healthcare related, that your CPA or other your non-healthcare attorney didn't know about is kind of giving us a lot of business at the end of the day. So it actually makes sense to go find a healthcare attorney from the get-go and do it right, because we have to end up having to clean these things up. So I think those are good points. But if there's anything you want to add on that, please.
Yeah, no, that's correct. I mean, I can tell you, we form entities and I review corporate documents, and I'll tell you an experience, right? Like within 30 seconds, you can see if a company agreement is it's if the company is formed in the right way, right? And an example would be, hey, I have the company agreement, and these physicians and this non-physician came to me and said, hey, we're going into business and doing this together, right? And so I look at them and I was like, well, explain how, right? So they show me, their company agreement that somebody else have drafted. It's not a healthcare attorney, of course. And within 30 seconds, I was like, sorry, you can't do this, right? You're not licensed. You cannot form part of the PLLC. And this is because, of the corporate practice of medicine, right? The CPOM. And when I tried to explain it, like at the beginning, I got like a lot of pushback, right? And so I ended up doing a complete full memo with all the like regulations and all case law, right? Explaining to them, okay, why you cannot have a non-licensed physician into your practice PLLC. And so, I mean, that would be just one of the examples. And, it's important that we educate and the importance of having documentation that reflects the intents of the party and that they're compliance with CPOM.
Yeah. And so I think we're and this is my fault, but I think we're jumping ahead a little bit here. And so the issue here is, yes, that CPOM in some way restricts who can own, for lack of a better term, a medical healthcare practice in the state of Texas. We'll get to that in a couple minutes. But to kind of bring us back on track and talk about the background of CPOM and again where it came from, I'll ask you that, Cindy. So where did CPOM come from? What was the original concern that created the doctrine and the enforcement in Texas in the first place?
Correct. So at a high level, the corporate practice of medicine is a doctrine. It's a legal principle that limits who can own or control a medical practice. The idea behind the doctrine is that medical decisions, medical judgment, they're taken on the benefit of the patient and not for financial interest. So, corporations are, corporations are not licensed to be physicians. They didn't go to med school. So why would you have, just think about it. It makes sense, right? Like, why would you have a corporate, making clinical decisions, right? So the idea is the historical purpose was to protect the physician-patient relationship and ensure that medical judgment is not influenced by any business interest, such as a corporation.
Yeah, and I think that's absolutely right. Is at some point I believe, and I don't know this for a fact, so you can check my math on this, but I think that all 50 states at one point or another, maybe still do, have some version of their CPOM. But yes, that's the idea, right? Is, I teach health law on the side, right? So one of the things I talk about in some of those classes, especially like the intro to health law classes, is we follow in healthcare, we have all these laws and all these regulations that were created like 40 or 50 years ago, Stark Law, kickback, things like that don't necessarily reflect, and that's another podcast, right? But don't necessarily reflect how we do the business of medicine in 2026. It's evolved and they didn't anticipate AI and, telemedicine and whatever in 1980, whatever, when they were drafting the Stark Law. But things like certificate of need, CPOM, and again, these are things that we might talk about later in another episode, but things like CPOM came out of that idea that medicine is for the good of the patient. Medicine is here, we're here to protect and serve and heal the individual. And so, yeah, I think at some point, maybe every single state had or still has some version of CPOM where they are trying to do that. They're trying to make sure that some nameless, faceless corporate entity out of state, out of the country, or whatever, doesn't come in and control the care that's being provided to a patient, right? Now, again, health medicine's evolved. Now we have, hospital systems that are nationwide. I'm sitting here in Austin. And you're in Houston, and there are plenty of hospital systems alone. I mean, we're not even talking about physician practices, et cetera, but just hospital systems alone that are headquartered outside of Texas in another state. So yeah, it's something that we're still dealing with. It's still evolving. But yes, that is the idea, that it'll protect the individual patient and keep big money, a nameless, faceless entity out of their healthcare.
Exactly. I mean, and it's a valid concern. And CPOM is so real, right? It's a doctrine. But what happens is this legal doctrine that it was up in the air because of the benefit of the patient and so on, it is actually now regulatory. It's instituted via statutes, right? So we have regulations in each of the states, and depending on the approach that the state takes. Texas, for example, takes the approach of looking at the corporate practice of medicine in a very strict way. So if you do want to open a business in Texas, right, because look, nobody's going to lie. Nobody's going to hide and say, hide the sun with one finger and say, no, there's no businesses. And, of course, there's a financial incentive for, everybody in healthcare. Yep. That's the reason why you have the value-based purchase, right, agreements. And that's the reason why we have initiatives that, go incentivize the physicians and the providers to be able to provide better care for the patient at a lower cost, right? Because I don't even want to go into the next level, which is like, oh my God, like the trillion dollars that we're spending in healthcare and all these other things, right? And my math may not be right in there, but the point is, there's still businesses, right?
Right.
We still want to be able to open up, medical spas and to open up practices and to have this injection of of investors as well, or capital, I should say. Not necessarily private equity. I'm just talking about, your Jane Doe that wants to open up a med spa, right? With, Dr. X, right? So how do we do that, right? So we do it very carefully. That's it. That's the answer. Structure it very, very carefully.
And you kind of touched on it too, and I think that's important. And the reason we started off with this topic for our very first episode, everyone considers and everyone assumes that Texas is this kind of laissez-faire, very business-friendly, like come to Texas, Texas miracle, low taxes, low regulation. But the reality is, and again, I only practice in Texas, but the reality is, or at least the perception is, that Texas has one of the stricter, if not the strictest, CPOM, corporate practice of medicine, doctrines, prohibitions, really, in the country. And so why is that, and why does it matter? And again, this is a situation where, I reviewed a contract a couple of weeks ago that came out of Arizona, and it looked like the people that drafted it, whatever lawyer drafted it, I'm sure is a good lawyer, but he didn't know anything about Texas regulation rules and any of these issues. And so I could tell that physician, this isn't going to fly in Texas. But why does that matter? And what do people need to know when they are thinking about coming to Texas, bringing their capital to Texas, and dealing with CPOM, something they may not even know about?
That's a great question, Cesar. And there's multiple implications of how to structure this, right? So you mentioned a couple of things, which is when you're in another state, right? And you're drafting documents, for Texas, for example, you should be aware that Texas does follow very strictly, meaning they dictate in the regulations, they tell you who can own the medical practice. Like, for example, a physician, right? A physician and an RN, right? They cannot own a medical practice. It doesn't exist in Texas. So if you go ahead and just say, hey, I want to form a medical practice with an RN, that's not going to fly. However, there's exceptions, right? So if you want to put the practice, if you want to go into business and have a practice with, for example, a PA, right? You could, so long as the physician has control. So you, as an NP, for example, a PA, you're not going to be able to have, 50-50 in ownership in this. So having, how do we do this? Making sure that we are, that we're looking at the regulations to see how can we structure, who can control, how does the money, the flow of the money works. If there's multiple physicians, there's other implications as well. How is the referral pattern? Is there any money, exchange and financial interest? There's a lot to go in it, and having a healthcare attorney that knows the state that you're in and that is licensed in the state that you're in, it's really important before you go ahead and try to, open up a business and have this flow of cash that you're going to put into the business, regardless of what kind of healthcare business it is.
So that's funny you mentioned that, because that MDPA kind of joint venture is an exception, right? And one that I'm not. I mean, I'll tell you, it's one that not a lot of people realize or know about, because it even tripped me up a couple years ago when I opened my practice. Probably lost out on a client because I didn't know it as well as I should have. Now I do. But again, I came from 10 years ago. An MD is an MD. Only MDs can open medical practices, and then here comes this exceptional MD and a PA if 51% or more kind of thing.
Correct.
But again, that even if you know that, most folks aren't going to realize. And I've had this call too, and I think maybe you have, where an RN or maybe an NP, but an RN usually calls up and says, "Hey, my physician's retiring. I want to buy the practice." And it's like, well, I think we can get you there, but it's not going to be what you think it's going to be.
Correct.
And a lot of folks are just like, no, like, I'm going to pay this doctor $250,000 or whatever amount of money it's going to be, and they want some sort of clarity and some sort of surety. And it's not like you're going to go and buy the corner ice cream shop or bookstore or whatever and just put your name on the title and keep running it business as usual. It just doesn't work that way.
That is correct. That is correct. It's unfortunate. I can think right now, like just a few weeks ago, as a matter of fact, I had one consult, and it was exactly on our end, the same case scenario, and that's, hey, this is what I want to do, and they wanted to put together a med spa, together, not even buying the practice, right? Together they wanted to own and operate a med spa. And so when I explained to her in 3 minutes, like, no, you can't do that, and this is the reason why, right? They're like, oh, okay. So, but and here's the thing. Saying you cannot do that, right? Or like, we will not recommend that because that is illegal, right? And so that, well, it's not permissible. Let me just rephrase. It's not permissible to do it. And nobody's going to put a knife and go and inspect everything, right? Right off the bat when you form a company, right? The problem, there's a lot more implications to that, not only for the non-licensed physician, right? For the non-licensed person, but for the physician. Yep. Because, there is also claims, right? Like, let's say that you're putting a wellness clinic. It doesn't have to be a med spa where there's no reimbursement involved, right? Like, it's only cash, like, reimbursement. It's not insurance reimbursement. But when you're going into the wellness clinics, and, we see, the GLP-1 clinics, right? Like the miraculous, weight loss, wellness clinics, right? That they're trying to help people. It's a noble purpose, right?
Right.
However, right, when you are entering into this space, you have to be conscious that if and when the audit comes, because it could be a complaint, it could be, just a random insurance, right? If you're taking insurance audit, right? And you do not have the right documentation and to show who has the medical judgment, right? That stays with the physician. And if you have an NP, if you have delegation agreements, right? Like, so everything it's interconnected. If you don't have this structure, you risk not only that, hey, the non-physician, it's maybe, depending on the facts, impersonating a physician, right? Because you're in there, you're in the PLLC, right? So why are you trying to say that you're a doctor, right? And there's a statute, right, that says, hey, and it's illegal, and there's criminal, for that. So I'm not trying to scare people. I think that's not the point in here, right?
Well, no, but I think sometimes people need to be scared. They don't know what to be scared of. So this is what you're doing.
Correct. To kind of explain, okay, hold on, there's a way to do this, right? There's a way where we can actually form a business, and we'll go through that through the examples, but it's not all bad. It's just making sure that you have the right pieces in place and that you structure it correctly with a healthcare attorney that can help you and guide you through that system. And I think that's the important thing that we're trying to, with us having this conversation is, trying to educate the people that, hey, it's real. The CPOM is real, and you need to be aware. And especially right now, there's a lot of, like, with the whistleblower and a lot of other, initiatives. Yes, it's not going to be per se illegal, right? And you're not going to go to jail, right? And you're not going to go, like, if you don't form the structure, compliant with law. But when that audit comes, should you not have this in place, this will not work in your favor. And the claims, the false claims there's a lot of implications, and so there's a way to go around it. I guess I'm just speaking out loud in here. And
no, and that's good. I want to talk about that for sure, but that's true. Like, this is what we're building up to, right? Like, in this episode is
correct.
It sounds small. It sounds relatively insignificant. It's not. And again, the intent is to protect the patient, protect the physician. But it's the figurative minefield that's out there that probably thousands, I would guess, if I had to guess, of practices in the state of Texas are probably in the midst of and don't have a clue, because, again, a year or two or whenever they formed their business ago, they had their corporate lawyer or their CPA or, again, we've heard it all, a non-healthcare attorney, somebody that is not familiar with these issues, form these documents, and here's your PLLC, and here's your LLC, and here's your tax ID number, and go open a bank account, and they're off and running, and they're probably making money at this point, but they don't know that the more that they do this, these folks don't realize that the more that they do this, they're walking further and further and further into that minefield, and they think they're doing well, and they probably are doing well, and they have good intentions. But then, yes, they get that complaint, the board looks into it, the Attorney General looks into it, CMS looks into it, or whoever, and all of a sudden, it's too late. You don't know how bad it's gotten because you don't even know that you didn't even see the problem at step one. Right. And so now you're 2 years into it. And so while all of this sounds theoretical, it's very practical, and it comes up all the time. Like I said, we keep saying this, it comes up all the time when folks are starting their healthcare businesses, and folks sometimes don't want to hear it. I'm sure you have examples of that where, and we can get into examples here now, and I'm sure we both have plenty, but folks don't want to hear that, like, again, I'm going to spend a lot of money to, quote unquote, buy this practice. My physician is retiring. I'm not picking on RNs. My mom and my sister are RNs, so don't get mad at me for that. I'm an RN. I've worked for this doctor for 20 years. This is my entire life, my whole career. I know the patients. I know the population. These are my people. I want to continue to serve them. I want to buy this practice. What do you mean you can't? I can't do that. What do you mean? What do you mean? What do you mean? It's my money. I have it. I've been saving all this time for it. And that's often not a very comfortable conversation, which, again, I'm sure you've had several of those.
Yeah. I can give you, regarding this, I can give you one example, and this is to piggyback off the first example that I had, where I had, this group of people that they wanted to have this practice, right? And it's a medical practice, and one is, provides the capital, right? And provides and I'm trying to think here and be very careful so we don't have any confidentiality issues, but one provides the capital and kind of like the labor work of the non-clinical part. And then, of course, the physicians provide the work, right? Like they're like the clinical decision making, and they, the clinical, the medical services are provided by the physician. The problem is the idea is not bad, okay? The idea is of the business it's an actual, it's a good idea. It's a business idea, right? Is how do we structure it right? And so what we did with them was, okay, no, you can't form the PLC together, right? Because, and we go back to like a non-physician. Yeah, go ahead.
Well, but that's good. So let's make sure people understand that a PLLC, professional LLC, is legally required to be. It has to be somebody who has a professional degree, MD, JD, etc. But the owners of the PLLC have to be individuals with those same degrees. So 5 MDs can form a PLLC, 2 MDs can form a PLLC, 6 JDs can form a PLLC, whatever. But they have to be the same degree and providing the same services. So what does that mean? It means that an MD and an RN cannot form a PLLC. An MD and a JD cannot form a PLLC, etc. So again, I don't know that folks know that, and I just want to make sure that before we get too far into it. So I cut you off, but yes.
No, it's great.
Sorry. Yeah.
No, and not only that, the statutes and the regulations also provide that if you're providing medical services, you have to have a professional entity. So a professional entity in Texas can be a PLLC, a professional limited liability company. It could be a limited partnership or a professional association, right? So going back to that example, the easiest for them was, to do a PLLC, right? And so what we did for them was structure in a way that you have the non-clinical portions and into another entity, an LLC, which it's an MSO or a management service organization, which we'll go a little bit into it in the next example as well. And then they provide all the labor, right? All the non-clinical labor. And then you have the PLLC, which is the professional entity owned by the physicians. And then, this is the so-called friendly PC physician, PLLC, MSO, right? Structure. And then you tie them up with a management service agreement in between the organizations. And here's the thing. In this particular case, right, it was the flow of money, right? How do we arrange for this, right? And it was because at the beginning I was like, no, wait a minute, we're gonna split everything, in between. And one of the things that come around the CPOM is also, how do you split that money? Because you cannot split fees, right, with a physician. Because again, what we're trying to do is trying to prevent from financial incentives to be the motivator or influencer of the medical judgment and decision-making process for the patient benefit. So again, at this case, once we, there's different ways to do it, and this is for another episode, right? But we ended up making sure that that fee it's not considered impermissible, and there's different ways to do that. And so that's how we solved that situation for this non-physician entrepreneurship with the physician business model.
And so this is good. Again, this is where we're going. This is where we get to the good news part, right? Like enough background. We've talked about what CPOM is. We've talked about what it's trying to do, trying to, again, protect the patient-physician relationship. Like you mentioned, you don't want to have any implication where that physician is splitting their professional fee with a non-physician or somebody else that's not licensed and not providing care. But there is a way to do this. And this is what, again, we do hopefully very, very, very well and have done for a number of clients. It is find a way to work within the current rules or current regulations, the current CPOM and other restrictions that are out there. It's not that the business, like you said, it's not that the business is a bad idea or that the intent isn't a bad idea, or like, look, I know you're an RN or a non-physician and you want to open this healthcare practice to serve the community and treat patients and make them feel better, and it's all good. I mean, those are good things that we want people to do. And we can get you there. We can bridge that gap, that regulatory legal gap. We can help you build that bridge, or we can build a bridge for you. to get you to where you need to go with those understandings in place. You can make money off of this, for lack of a better term, but you just have to do it the right way, and the physician has to do it the right way. And we have to draft, again, going back to square one, we want to make sure that your company is formed correctly, your documentation is appropriate, and that we have the right agreements in place to show if the medical board, the AG, or somebody else comes along and wants to see how things are running, we can show that we are complying with all these, CPOM and other regulations, and we're not splitting fees, we're not doing any of these things that we're not supposed to do, that again, probably thousands of practices out there, hundreds at least, maybe have no idea that they're doing. So, again, sounds theoretical, actually very practical, comes up a lot. But I mean, I know we get this question a lot. So again, going back to the examples, you get the common situation, which is somebody who's a non-physician, they're an entrepreneur, they come in, they want to open a practice, a clinic, a med spa, IV hydration, whatever it is. You already mentioned that, so I just want to put some more kind of meat on the bones here, but we already mentioned the PLC is the physician. Let's just keep it simple. One physician forms a PLC. That's the physician's professional medical practice entity. The non-physician opens a second LLC, not a PLC, but just an LLC or other corporate entity, and that is the entity where the non-physician handles their portion of the quote-unquote the practice, the non-medicine practicing part of the practice. And then what comes next?
Yeah, and then you have a management service agreement to tie up this, right? So basically, and this is on a friendly, right, on a friendly PC.
A friendly physician model, right?
Yeah, correct. Now, this is when, so if the physician, there's a couple of ways to do it, right? Like, so we're at the very basic level. Let's say that the physician, that you want a joint venture, you want a partnership, right? So then the physician will participate in the MSO. And then, but the physician will also keep the PLLC or the medical entity, and you will tie them through a management service agreement where the physician will provide the services, the medical services for the business, right? So all the revenue, the clinical revenue will come through the physician's entity, and then the PLLC, right, will pay a management fee that needs to be, fair market,
right,
and not into account to referrals, commercially reasonable, and there's other things right in there, making sure that it doesn't reflect like you're splitting fees or that
right,
this is a sham, right? Like,
right,
no, in reality, you own the practice, right? And so that's how you will structure it, right?
Yeah.
And there's way more details than what
right,
I'm trying to say in here, but
yeah,
that's one of them. Then the second, and it's still friendly, right, is when you have the PLLC, and the PLLC does not participate in the MSO. So that's when you don't have the physician really investing in the business. Right? They really are there, they provide, and then they get, it could be a medical director fee, right? But the bulk of the business revenue will come as a management fee to the MSO,
to the non-physician, right? Okay, so again, let's make sure we unpack this and keep it simple, because we are legitimately glossing over a lot of little things that do matter, that we can talk to you about individually. But the basic idea, like we just talked about, you have the Dr. X is the physician, they own Dr. X PLLC, which is their medical practice. That's where their medical license lies. They're the ones providing the medical services. Cindy Peters, non-physician, wants to partner with Dr. X to open a clinic. Cindy Peters in her LLC can do what we call the MSO, the Management Services Organization. So that PLLC, the non-physician PLLC, Cindy's PLLC, is the Management Services Organization. You are providing all the management services, of course, all the back off, yeah. So billing, janitorial services, supplies, furniture, staffing, non-medical staff, anything that isn't the practice of medicine. Your MSO, your Management Services Organization under your PLC, non-physician PLC, is providing all of those services. And to tie them all together, to tie you to Dr. X, who is providing the service, the medical services, you have an MSA, the Management Services Agreement. That is the sort of the magic document that, again, we're glossing over a lot, but that's what's going to tie all this together and basically make all this compliant under our current regulatory and legal structure. So again, that's important. That's the good news, right? Is we told you all these bad things. We told you this minefield is out there. Here's how we get through it. Again, we're glossing over a lot, but here's how we generally get through it. The second example you had is sort of the same thing. You have the physician, Dr. X has his PLLC. He does not necessarily have an MSA agreement with the MSO, but he's just doing, he's providing his medical services kind of as a supervisor. He's getting supervising fee, a fee for his limited engagement in the practice and his provision of healthcare to the practice. He's not as tied in as the first example, which is probably, that first example is probably the more common example that we see. But again, there's more than one way to get through this. So again, that's the good news there, is that you can have the corporate MSO, MSA setup, which we do fairly frequently. So to kind of keep the conversation going and tee you up for some more examples, like I said, we see this a lot. We see this very frequently. You probably get multiple calls a week about these types of situations for folks that understand, hey, I might have a problem here and I need to clean this up. Med spas, wellness clinics, IV hydration practices, all the way up to medical practices, to clinics, and so forth. So Cindy, like I said, we're in the good news section now, but walk us through a real life situation. Somebody comes in, let's just say they're a non-physician. Let's keep it simple. Let's say they want to open a med spa. And again, spoiler alert, the state of Texas is taking a closer look at med spas now. There's been some incidents out there that you can go and look up on your own of things that have happened, because again, there's money, follow the money, as I like to remind folks. And so there's more money coming into med spas because there's a perceived return of investment. But okay, keeping it simple, you have a entrepreneur coming into Texas, wants to open a med spa, not a physician. They plan to hire a physician to come in and assist. What do they, you get the call, right? A week into it, 2 weeks into it. What is sort of the things that they've usually done wrong there?
Yeah, so I can think of one example right now, and it wasn't a medical spa, but it was a wellness clinic. You know how they have franchise agreements, right?
Yep.
And a lot of franchise agreements, and they're just saying basically they're hey, if you invest, right, X amount of money, you're going to have a turning ready key. This particular franchise is, of course, out of Texas. It's not in Texas. I can't remember the state, but let's say non-Texas, right, franchise. And, turnkey ready, right? Here it is, right? And so they already did they already signed it. Basically, the entrepreneur already signed it. He's non-physician, and comes and says, Cindy, can you just, I hear that there's a lot of regulations, but I don't know, right, that they say it's turn ready. So I looked at everything. I look at all the corporate documents. I look at, and here's what they didn't have. They missed in the franchise agreement that they have provisions for non-strict. They didn't state which state. They just say, you go to your state, and if your state has CPON regulations, you need to find your own attorney. And it literally say that.
But it's buried in the contract, right? It's like on page 30 of a 100-page contract.
Correct. And so it tells you in there, and it tells you you're going to need to have, a management service. I mean, they tell you, but how they missed it. Okay, so this is one of the examples that I can think that it just like the latest example that I can think of. And what I had to do, they didn't have a physician they had a physician, but they didn't have delegation agreements, nor they did have a management service agreement in between the physician and the LLC, right? So what we had to do was go through the system, and not only that. So if you think about it, right, like that, the franchise agreement is a contract. It's an agreement. It's in representation that you sign as an entrepreneur. You're signing in the business that you represent, that you're doing all that. Like if you fail to comply with one of the many representations you sign, that's a breach of contract.
Breach of contract.
So you have other implications that go in besides the corporate practice of medicine, besides having the documents non-compliant. It's more than that. So that's one of the things that I can tell you. It's missing in almost every single client that the delegation agreements are not there. And if they are, they're drafted, I don't know how long ago, because it doesn't have anything that the regulations tell you, currently.
Yeah, and so again, that's a good thing that would be good to unpack a little bit more. And I'm fascinated by the use of franchise agreements in medicine. I get it, and it's sort of a natural evolution, but it's just so weird to me because, again, you're a Texas licensed doctor. You've been practicing here for 30 years. You've built a great career. You're doing great. And then, hey, I have this opportunity to franchise, and you think, oh, this is, I just need to sign this document, and then they're going to tell me what to do. And it's not like you're opening up a Subway down the street or whatever. It's completely different. Although you think that's what it's going to be because you just hear franchise and you're like, oh, well, somebody's got me. I'm protected. Like in 99% of those cases, you're not. Because like you said, there is a disclaimer in that out-of-state franchise agreement. Somebody comes in from across the country and is convinced you to buy, you physician, to buy this practice, to start this practice under our franchise model. And we know how to do things in, Iowa or Illinois or wherever state they're coming from. But they disclaim in there, and it's buried in this fine print, that you need to go and do whatever you need to do to comply with Texas law. We're not going to protect you there. That's on you. We don't practice in Texas. You do. You're on your own there. And so, yeah, a lot of folks miss that because they are convinced, for whatever reason, that I just need to sign this contract. It's 100 pages long, so it must be good, and it must protect me, and we're off and running.
Yeah. And another thing that I think is important to cover and unpack, Cesar, is that, like medical spas,
yeah.
Right? What is a medical spa, right? It's a hybrid between a spa where you have your facials, right, done, and where you have you have a little bit more, right? Mm-hmm. You have the utilization of medical services because you're getting Botox, right? The infamous Botox, or you're having anything that penetrates the skin, or the injections of GLP-1, right? That's medical services. Recently, Texas just passed law that, tells you as a med spa, okay, and tells, I think that the approach of the TMB, that the Texas Medical Board, has always been around those same areas, like, hey, this should be regulated, right? But it wasn't until last year that it became effective in a regulation, right, to where, correct me if I'm wrong, but it was last year. And so 2025, where it basically tells you, no, sorry, esthetician, you cannot go ahead and put Botox, okay?
Right.
You cannot go ahead and do, these treatments that are, are medical treatment. The injections of GLP-1, Botox, all these other things are considered medical treatment. That is the reason why they're called med spas, okay? So in order to have a med spa, you have to have a physician overseeing the clinical and the medical services. If you have and many people say, oh, I'll have an NP or I'll have a PA. Well, they have to have, or an RN, right? They do have to have a delegation agreement in between the physician and again, and the provider. Again, these delegation agreements are very specific, and if I'm not mistaken, it was also last year where these delegation agreements are basically now stating the requisites and what should go into this delegation agreement. So if you haven't looked at your delegation agreements in the last year, you should, because there is more to it than meets the eye.
No, and I think med spa is a great example, and you're absolutely right. I mean, having worked at the Capitol for a number of years and working on these issues, the law and the regulation takes a couple of years to catch up to the reality. So we're seeing now, 2026, 2025, the changes that are the result of things that happened. I would say probably mostly at med spas. I'm not going to just completely dump on med spas, but mostly at med spas where you did have people who were unlicensed injecting Botox or doing, something that constitutes the practice that very clearly, not even like close, but very clearly constitutes the practice of medicine as the state of Texas defines it, and causing injury to a patient, if not death sometimes, I think, in some of those cases. So the law changed to try to address that. You don't want somebody doing Botox injections in the back of a convenience store or something like that, I'm just making that up, but I wouldn't be surprised if something like that actually happened. But yeah, med spas is a great example because people see that, they say, look, this is easy, I can do this, I can give an injection, I know how to use a syringe. But the state of Texas there's a legal definition of the practice of medicine in the state of Texas, and it's usually what you said. It's anything that penetrates the skin, injections, all those sorts of things. Your RN may be qualified to give injections, may be qualified to inject somebody with GLP-1s or Botox or whatever it is. And it seems like a very simple procedure. You're just giving them an injection, it's like drawing blood or whatever. But that is the practice of medicine. And if those documents and those protections, those things aren't in place to do that appropriately, you've got a big problem. And again, think about how many hundreds of med spas are out there, maybe thousands, just med spas, where this is a problem and they don't even realize that.
No, and not only that. Now that we're talking and I'm thinking about it, there's more to it as well for the physician side, right?
Yeah.
The physicians are, and in some cases they don't know now that the law has changed, and now these delegation agreements, you need to go and register them. Well, let me rephrase. You don't need to register the delegation agreement. You need to register with the TMB that you are delegating functions to XYZ provider. So you really do need to have your delegation agreements in place in case there's ever, a question regarding.
And you need to keep them up to date. It's not just like a reporting and then you're done. You need to keep it up to date, and you need to go back and do it on a regular basis. Yeah.
Yeah, and as a provider, right, like as an NP, like as a practitioner, right, advanced practitioner provider, that is how you're able to practice.
Yeah.
Because you have that delegation. So if you don't have it, you need to ask for it.
Yeah. And I think you and I would say the same thing, as we get calls from physicians from time to time that are in a situation that they don't want to be in, a situation where their license is potentially jeopardized and they are at risk of losing it. And again, at that point, it's it's not necessarily too late, but it's like, hey man, you should have come to us, you know. If you'd come to us a month earlier or a year earlier, 2 years earlier, we wouldn't have this situation. But now it's going to cost you a lot of time and money to try to clean this up if we can even get you there.
Correct.
But yes, at that point, it's I'm about to lose my license. I'm not going to be able to practice medicine. I'm not going to be able to earn a livelihood. Help me do something. And it's prevention versus treatment. It's a lot easier to prevent it and a lot cheaper to prevent it on the front end than try to fix it on the back end when it's become a major problem. So you kind of alluded to this, and I know we need to wrap up here soon, but we kind of talked about consequences for the parties when this goes wrong. But let's talk about that. Like, how do these become issues? Like, where does the scrutiny come from? How does all that pop up? And then what are some of the potential penalties, outcomes, negative effects for the people involved in these medical practices, generally speaking, when something isn't done correctly, it's left to kind of continue to be done incorrectly, and then now it's come to light?
So that's a great question and great to wrap up, Cesar. It's not like not having these documents right in full compliance is going to automatically deem it and that you're any penalties related, right? The problem becomes, let's say that you have a complaint, right? And that complaint goes into the medical board, or that complaint, goes into OIG, or
which I'll jump in and say, fact, medical board has to investigate every single complaint. So you can make anonymous complaints too, and a lot of folks don't realize that. But if that complaint is raised to the medical board, they are required, even if it's a frivolous complaint, they're required to come in and investigate.
Correct. So it could be a complaint, and many people are going to say, well, I don't deal with insurance, Cindy. I don't deal with Medicare. I don't deal with Medicaid. I don't deal with any of that. You're a medical practice, right? Even if you're a med spa, you still consider a hybrid medical spa. So you are subject to TMB regulations, right? The Texas Medical Board regulations as a physician. And you are also subject to, Patient Medical Act in Texas. You're subject to HIPAA federal laws because you're dealing with, personal health information. Okay, so you're still subject to all of this, huge, massive amount of layers of regulations, not only at the federal level but at the state level. Yep. And so, let's say that there's a complaint, right? And they have to investigate, right? Or let's say there's an inspection, right? Or an audit, right? Like an unannounced audit, right? And right now, the initiatives are, and you can go read a little bit more about this, but there's a lot of initiatives that are now being pushed, not in the country in general, right? To go after healthcare fraud, to go after, because why? Because there's money involved, right?
There's money involved.
They know that there is a lot of, people that don't follow the rules, and then they just go around their merry way and thinking that nothing is going to catch them. And, so that's the reality, okay? Is when that audit comes, you do not have your documents in place. You cannot prove there's a violation of CPOM, right? And a violation of CPOM, the corporate practice of medicine, it could have a lot of implications for the physician, right? Because you're basically letting somebody else, make decisions for you, right? Or influence your decisions in your medical, right? So that could be for your physician or for your NP and your, your providers, any board's investigations and possibly, penalties and getting your license taken away. That would be extreme, right? But I mean, it has happened.
But it's happened. It's happened.
Correct. And then, for the non-physician, right? Depending on the facts, like I mentioned at the beginning, hey, why are you impersonating a physician? You're not. Why are you getting this? You're not, right? So there is, depending on the facts, this could actually mean, not only civil but criminal consequences for this types of setup. So you need to be really careful of that. You really need to, at least once a year, look at your risk assessment, do a risk assessment, see what you're missing. If you haven't done it, go ahead and do it. And so,
or bring you in to do it, because you do a lot of those as well.
I do a lot of the risk assessments, and the problem, the penalties that the OIG imposes, right, after the investigations and non-compliance and or recoupments, right?
No, I mean it's a lot, and I get it. I mean, because that's the thing is, they don't teach you this stuff in law school. They don't teach you this stuff in medical school. They don't teach you this stuff in nursing school, and it's you run into people that love what they do, whether they're a nurse, a doctor, or anything in between.
Yeah.
They love what they do. They love helping people. They love being in their part of their community, and they have to make a livelihood. They have to pay their mortgage. But they don't realize that if something goes wrong, it's usually not licensure. Usually not you're going to jail. Maybe you have to pay a fine or something like that. But like you said, the federal government, depending on who you talk to, makes $3 for every dollar they put into fraud investigations, because it's just, there's so much out there that they haven't even uncovered yet, because they're years and years behind, that it is an incredible return for the federal government, and it's essentially a moneymaker. So we always tell folks, watch out for that.
Correct.
But if you don't know what you're doing, but you have good intentions, and these little things start to add up and add up and add up, after enough time, those little things all add up to one really big thing, or multiple really big things. And that's where you potentially have civil penalties, pay a bunch of money, regulatory penalties, potentially lose your license, or criminal penalties if there's intent to do something, and hopefully, you're not there where you're intentionally doing something. You could go to jail. So it is important. But again, I think the takeaway here, and the thing that we've really tried to unpack with this episode, is that this is something that seems small, seems trivial, seems, like I keep saying, very theoretic, but it's very, very real, and it's, you're making these little incremental things that could potentially turn into something big, and we want to make sure that we catch that before you get there.
That's correct. And the risk assessment, right? And I know I lost the train of thought, because I was like, here's the thing. OIG will not penalize you, for not having the documents in place per se, right? Depending on the intent, depending on the facts. But if you do not have a risk assessment in place, okay, and as a healthcare provider, as a healthcare organization, as a healthcare, you should, because you're dealing with PHI, right?
Mm-hmm.
And you're dealing with all this frame of regulatory components that you have to abide, right? If you go back into the penalties and you go back into like why, right? 90% of the time, it's the lack of a risk assessment. And you don't have to have a healthcare attorney to do it. You can do it in your organization. Depending on the size of the organization, that's how they're going to assess, right, what you're doing, if it's right or wrong, right?
Yeah.
So that's number one, having a risk assessment. And then number two, mitigating. What are you doing after you find out? So if you know that you don't have the documents in place,
get them in place.
Get them in place.
Yeah.
Correct.
Yeah.
So
Yeah. So I mean that's kind of to try to wrap this up. That's what we're saying is basically, look, there's a takeaway. There's this thing called the corporate practice of medicine. CPOM in Texas. You may not know it exists, but it's out there. It may sound sort of squishy, abstract, like it doesn't matter, but it has serious implications from the very beginning, from the moment you decide to start your business, and how you incorporate and how you form all these things and how you operate it. And if you don't have it, it's not necessarily a death sentence. It's just realize you don't have it, and let's fix it. So yeah, that's I think that's the theme of. Would you agree with me that that's what we try to unpack here today?
Absolutely. We're trying to give you the tools, educate people, and just spread the word. It doesn't have to be perfect, but you gotta try hard to be able to meet as many as the requirements as you can to be compliant for your own safety, for your own benefit as well.
And that's where we wanted to start this podcast, and hopefully we keep it going and people find it useful. But it's not that we're trying to discourage you, healthcare provider, anonymous healthcare provider listening to us, from doing what you're doing. What you're doing isn't the problem. It's just we want to make sure that you're doing it in a legally compliant, appropriate way, and hopefully we can give you that simple real-world advice to get you there and help you continue doing the great job that you're doing. It's usually not the idea and the business itself that's the problem. It's just the way it's structured, everything kind of that comes with it that we want to make sure you have right.
That's right.
Okay, well, Cindy, thanks for joining us on Healthcare Business Unpacked.
Thanks, Cesar. The conversation was fantastic. We hope that you found this episode helpful, and we look forward to continue these conversations with more information and more healthcare business tips to unpack.